Recently, we are witnessing the conflict between two sovereign nations, that is, Ukraine and Russia. The conflict is going on till date, and Ukraine has invoked the jurisdiction of International Court of Justice by filing a case against Russia. The question which arose before us is, if we are not a student of international law, that what is this International Court of Justice? Whether Ukraine can file, a sovereign state can file a case against another sovereign state in the International Court of Justice. As yesterday, the proceedings were held before the International Court of Justice and Russia has not joined the proceedings. What are the consequences? Whether an ex parte judgment or a decision can be taken by the International Court of Justice in the absence of Russia, or in case the Russia appeared before the International Court of Justice during the subsequent proceedings and raised an objection regarding the jurisdiction of International Court of Justice to entertain this case on behalf of Ukraine, what are the consequences? And in case a decision has been taken, a decision will be taken by the International Court of Justice against Russia, whether that is binding on Russia in the circumstances. So in this video, I will try to answer all these questions. And before discussing the answers to all these questions, we must know what is the origin of International Court of Justice, what is the composition of International Court of Justice, and what is the jurisdiction and authority of International Court of Justice in international law. As you are well aware that the League of Nations was established by the victorious states after the World War I. And under the League of Nations, a permanent court of justice as an adjudicatory body for deciding the disputes under international law was established. League of Nations was established in the year 1920. The Permanent Court of Justice held its meeting, the first meeting, in the year 1922. During its tenure as Permanent Court of Justice, has decided 29 contested cases and 27 advisory opinions were given by the Permanent Court of Justice. However, with the end of the League of Nations, this court was also abolished. Thereafter, again you are well aware, there is an international body in the shape of United Nations. United Nations is governed by a charter which is commonly known as UN Charter. And under the UN Charter, International Court of Justice was established, and it has been declared as a permanent principal organ of United Nations. And a statute of International Court of Justice has also been passed by the United Nations. If you want to study the UN Charter or the Statute of International Court of Justice, I have given the link in the description box. You may read the complete charter as well as the statute of ICJ. Here, because in the video I am only discussing the outline and not in detail, so that you may understand and have the understanding about the whole system. Now, this International Court of Justice, we can say, stepped into the shoes of Permanent Court of Justice. Some jurists have also stated in their statement like this. This International Court of Justice has a permanent seat at Hague. All the members of the United Nations are ipso facto, by virtue of being a member of the United Nations, have become the member of the International Court of Justice. But any state which is not member of the ICJ may become the member of the ICJ in case the Security Council recommends for such membership and the compliance of the conditions so imposed by the General Assembly. This International Court of Justice is comprising 15 judges. The bench is comprising 15 judges. All the judges are elected by the Security Council and General Assembly separately. They have a 9 years of term. They can be re-elected also. Dr. Nagendra Singh from India was elected as judge of International Court of Justice, and he joined as such in February 1982. He was elected as president of the International Court of Justice in the year 1985. However, unfortunately, in 9 was re-elected, but unfortunately during his second tenure, which was to end in the year 1991, Dr. Nagendra Singh died during his tenure. And the remaining period of his tenure was served by Justice R.S. Pathak, who was elected as judge in the year 1988. And he served for the remainder period of Dr. Nagendra Singh as judge of the International Court of Justice, which came to an end in February 1991. Thereafter also, now even presently, Justice Dalveer Bhandari, a judge of Supreme Court of India, was elected as a judge of International Court of Justice. On completion of his first tenure, he was again re-elected as judge of the International Court of Justice. Now, there is a custom which has been developed that all the 5 judges shall be from the permanent members of the Security Council, and the remaining 10 members of the ICJ are selected and elected from the main forms of civilization and principal legal systems like Latin America, Europe, Africa, and Asia. So there is an equal proportional representation all over the globe. ICJ remains in session throughout the year except on the declared judicial vacations, and those judicial vacations are declared by the International Court of Justice. Now these 15 judges forms a bench of the International Court of Justice, and very important question is that when there is a dispute between 2 sovereign states and the judge belonging to that sovereign state is a member of the bench, whether in ordinary parlance we know that such a judge who has an interest in the litigation are recused from the proceedings, but this is not so in the proceedings of the International Court of Justice. In the International Court of Justice, rather both the sovereign states or all the sovereign states which are contesting before the International Court of Justice in a particular form of litigation, they should have the representation in the bench. I'll just share with you an example. There was a case, Pakistani flights over Indian territory in 1972. This matter went to the International Court of Justice, and at that point of time, India was not having any judge in the bench of International Court of Justice. Then Dr. Nagendra Singh was appointed as an ad hoc judge to represent India in the bench. So, the sovereign states which are litigating, they should have, or we can say must have, the representation in the bench also. Take an example of Jadhav's case. A judge from India that is Justice Dalveer Bhandari, was a member of the bench when there was a litigation between India and Pakistan. Similarly, a judge from Pakistan was also a member of the bench. So this is the practice which has developed, which is not in the municipal laws. Then there is a concept of jurisdiction, how the International Court of Justice can assume the jurisdiction. Very simple. If one sovereign state is filing a case against another sovereign state which is governed by a bilateral treaty or a multilateral treaty, or both the sovereign states have given the consent, then the International Court of Justice assumes the jurisdiction. Now we'll discuss the case of Ukraine. Now Ukraine has filed a case. If Russia is not submitting to the jurisdiction of the International Court of Justice in this particular dispute, the International Court of Justice cannot assume the jurisdiction and decide the issue. However, there is one exception, that is called optional clause, optional declaration. If a particular sovereign state has made a declaration of accepting the jurisdiction of the International Court of Justice in certain circumstances against certain sovereign states, then the contesting sovereign state may file a case, and in case the other state has already made an optional declaration, then that state is bound to join the proceedings. If not join the proceedings, the International Court of Justice has the jurisdiction to decide the matter. Now in the present case, if the Russia has not made any declaration under the optional clause, then Russia is not bound. One, if they are having a declaration or of an optional clause but not with the Ukraine, or not having any bilateral treaty on the basis or on the strength of which Ukraine is enforcing its rights before the ICJ, then the ICJ cannot proceed. So ex parte judgment is not the question before the International Court of Justice in these circumstances. Then what is the binding force of the judgment? A decision has been taken by the International Court of Justice. One thing is very clear, that judgment, that decision is binding only among or between the contesting parties, and that too only regarding that particular dispute. And the most important thing is, the decision of the International Court of Justice is not having a precedent value. That is, a previous decision of the International Court of Justice is not binding in the subsequent proceedings. However, it may have a value, it may guide the International Court of Justice to decide the subsequent issues, but it is not binding. And the last and the foremost is that the International Court of Justice decision is final and is not appealable. Thank you very much.